Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Over the course of the past few days, there have been two filings that have raised some questions. In this case, that has been under seal for a very long time, and that has been subject to a non-dissemination order, aka gag order, since the very beginning of the case. The two documents, one is a notice of hearing, which we just did a presentation on and published today. This is May 3rd, 2025. If you have not had an opportunity to watch that presentation, I very strongly recommend that you do. The second is a notation on the case summary page of May 2nd, 2025, indicating that one of the parties, we don't know which, filed a notice of their penalty phase, lay witnesses would be, and also a request for victims' impact statements. Now, this is very curious, not only because we don't know who filed this document, it's not noted on the case summary page, which very often does tell you who filed the document before it appears on the public docket, if it is a public document. We know which documents are public versus those that are closed and sealed by icons on the case summary page maintained by the Clerk of Court to document all key events in the case. If you see an icon, PDF, that signifies a public document. It should appear on the public docket at a certain point in time. If you see one with a lock and key device, that is under seal. It is closed. It will not be released to the public until the court orders its disclosure. Now, what's unusual here is that trial is not set until the 11th of August, 2025. That is more than 3 months from now. The trial that is set is a bifurcated trial. It is two trials, if you will, in one. Only one for sure will proceed. The other will only proceed in the event of a return of guilty. The portion of the trial that is scheduled to commence August 11th, 2025, that will occur barring any unforeseen development between now and August 11th, is the case in chief. It is also known as the guilt phase of the proceeding. That is where the state of Idaho bears the burden of proving at beyond a reasonable doubt evidentiary standard that Mr. Kohberger is guilty of the 5 felonies he has been charged with by indictment in trying to persuade that future jury that will be selected commencing July 30th to return a verdict of guilty. If that jury returns a not guilty verdict, there will be no second phase of the trial, because the second phase of the trial is contingent upon a guilty verdict being returned during the case in chief. If the jury returns not guilty, this case ends. There is nothing further to do other than housekeeping things. Mr. Kohberger cannot be charged again with these 5 crimes. Double jeopardy would then attach. It is only if there is a return of guilty, then matters go into the next phase, which is the penalty phase. And the goal of the penalty phase is sentencing. What sentence would be appropriate given the guilty verdicts? That is what would be on the table during the penalty phase of these proceedings. Mr. Kohberger is considered innocent of the 5 serious felonies that he has been charged with, that he will stand trial on at the upcoming case in chief, until or unless one of 2 things happens. He either pleads guilty or is adjudicated guilty by that future jury during the case in chief. So with that background, I would like to point you to a case that is another high-profile Idaho case, which is right now on appeal. You may see it, and you go up on the case, onto the Idaho Cases of Interest Supreme Court website that maintains the Kohberger documents. The case summary page, as well as the public documents, can be found on this docket. But you also see that the Vallow, aka Daybell, Laurie Vallow, aka Daybell case file is also located on that very same website. There is a court order from state of Idaho versus Laurie Noreen Vallow, aka Laurie Noreen Vallow Daybell, which I believe will shed further light as to when victims' impact statements come into play. It says here on May 14th, 2023, a jury returned a verdict finding the defendant guilty of all charges in the amended indictment. The court will sentence the defendant on July 31st, 2023, in order to facilitate the pre-sentence investigator's preparation of the pre-sentence report and enable adherence to, and then there's the applicable Idaho statute, and upon receipt of a number of forms filed by individuals who wish to exercise victims' rights in this case, the court enters the following order to clarify who is statutorily entitled to exercise victims' rights in the case, including who may submit a victim impact statement to the court at sentencing or address the court. You can read the rest of the order to gain further information about what was before the court there regarding victims' rights, including victim impact statements. But this is an example, I believe, that shows that a victim impact statement comes into play during sentencing, and as a condition precedent, there must be a guilty verdict. So therefore, we have this weekend 2 questions. On Monday, May 5th, 2025, why the court is convening a hearing, which is sealed and closed to the public. So the public cannot attend the hearing either virtually or in person if someone wishes to witness the proceedings by going to Judge Hippler's courtroom. That courtroom will be closed and sealed. Can't go in there and watch it, can't watch it virtually. And number 2, we don't have notice as to what the purpose of this hearing is. This is a first in this case. That was the topic of my last presentation. And then a couple of days after that notice of hearing, we see on the case summary page, why is one of the parties asking for victim impact statements now, during pretrial, more than 3 months before the start of the trial? We're going to continue to monitor the docket as any further developments arise. We will notify you. If you like our content, I would greatly appreciate it if you could hit the like button and consider subscribing to our channel. It would really help us out. If you have any comments, any thoughts, any feedback, please leave it here. And until next time, this is Kathy. Thank you for joining us here today.